Hi, everybody, and welcome to Raw Law. This is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and welcome, everyone. So let's get into it. We're here to answer your questions and to talk about your comments. It's all about you, the viewer, on this episode. So yeah, let's get into it. Let's see here. I see a question from Tawabin Patel. Hello, attorney. Why would the defense be asking for CVS pharmacy records? Okay, so when you have a lawsuit, what happens is you put your physical condition at issue. That means that's one of the issues, right? The extent of your injury. So that what they would want to do is if you're saying that you're going to a pharmacy, you're getting certain prescriptions, certain medications, they'll want to request those records just to verify. And also they could bill for it. So that's one of the reasons, But yeah, it's just they want to basically get all the records and have all your medical records. And then SCB says, are there actual laws in New York City for time limits once discovery demands are made for the defense attorneys? How can you get them to respond more timely? I mean, there are rules about that. You're supposed to respond within 30 days, but sometimes they don't. And if they don't respond, or they do respond, but they respond just by saying, objection, or this is too burdensome, which is a response, but it's not the response you're looking for, right? What you're looking for is a meaningful response. So then you have to write them a letter. They have a requirement to meet and confer. So you might have to meet with them. The attorney will have to meet with them and confer and say, look, this is not a good faith response. Can you give me a real response? And then either they will, or if they say no, we're going to rest on this response, then you have to file a motion and wait for the judge to then order them to give you a response, which is a little bit unfair. And some of the courts lately, especially after COVID, have just been slow. So you could be waiting for the judge for 3 months or 6 months just to tell them that issue an order that they have to respond to what they have to respond to anyway. It's kind of silly, but unfortunately that's one of the things that's happening. And then Cadian says, how long does it usually take to get a trial date after finishing discovery in Long Island? So in Long Island, I would say about a year, maybe a little bit quicker. It depends where, like I believe in Nassau County, I think I heard it's about a year. And same thing for Suffolk, might even be a little faster than Nassau. And then let's see, Red Shadow says, hey, Arkady, I was hit by a tow truck from the passenger side. It was kind of like a rear size wipe open, Newburgh, New York, Orange County. I had arthroscopic shoulder surgery to repair a torn labrum. Plus I had 3 back injections for my lower back and 2 knee injections. And of course I'm getting physical therapy and chiro. How much do you think this case is worth? Yeah, so if you're hit by a tow truck, as long as the tow truck has enough insurance, usually they do, usually they have at least $1 million. So if it's like a rear end, I think that's what you mean, a rear end, with those injuries. So you have arthroscopic and you have injections. I think that should be worth anywhere from at least a few $100,000. I would say with the arthroscopic surgery, it should be worth at least a few $100,000, like $200,000-300,000 minimum, probably more if you have injections and that. But you have to make sure that it's a real trial attorney that goes to trial, that gets jury verdicts. That's very important, and that they're willing to prosecute it. Because if you have a real trial attorney that's pushing the case, they're going to pay you much more than if they see it's just a lawyer that doesn't go to trial. Then they'll say, look, whatever we give, they're going to have to take this. They have no other recourse. What are they going to do? So the insurance companies know that. So you have to make sure that. But if it's a trial attorney on it, it should be at least a few $100,000, I would say. Okay, and then Kristen says, hey, Arkady, is there an average time frame for Medicaid to send my lawyer the amount? Medicaid. I mean, Medicaid usually, I believe, takes a few. I mean, I don't really know. I don't really deal with that myself, to be honest, so I don't really know. I'd have to ask my office manager. She kind of deals with that part of it. But I think Medicaid and Medicare, I know Medicare is a little slower because that's more of a system, and it's Medicaid, I believe, deals with like the Human Resources Administration. Sometimes it's with New York City. They sometimes can respond in a few weeks even. but I'm not sure exactly of the time frame. I know at one point some of the attorneys that were there left and they were a little bit overworked and it was hard to get anything from them. But I don't know if that's been fixed or if that's still going on. I know at one point, I think a few months ago, there was an issue with them and they were kind of very, very slow and not responding, unfortunately. But yeah. Okay, let's see if there are any other questions, or if there are no questions here, what I could also do is I could jump into the channel and answer some questions in the channel. Let me see. Yeah, if I go to our channel, we might have some questions over there in the comments. Let me see here. Oh, and Kristen says, I appreciate it so much. Love your show. We have spoken previously. Yeah, I think I remember. Yeah, thank you so much. I really appreciate that. I think I remember. Yeah, we spoke before. Yeah, feel free to text me too. I could find out and text you back. I just forget, but I think, yeah, probably at least a few weeks. They're a little slow, Medicaid, unfortunately. Let me see here what comments or what questions we have. Oh, here's a question. William says, hi, Arkady. What kind of injury can claim policy limits? So yeah, it depends on the limits. Like for example, if you have a $25,000 limit and you have an arthroscopic knee surgery, well, that's enough to claim the policy limits on that. Now, if you have a bigger policy, like $1 million, maybe one arthroscopic knee surgery usually isn't enough to get a full $1 million. So you would need something more, maybe like a total hip replacement. Like we just settled a case with a total hip replacement for $1.2 million. I just did a video about that, so we're going to put that out there soon. And I think we had the video out where we got $2.2 million on a lower back fusion. So you could see, like, if you have a $1 million policy and you have those kind of injuries, you would probably clear that limit. So it just depends on the limit, because each limit is different. Usually with cars, it's 25,000. Sometimes it's 100,000. So with 100,000, I mean, if you have 100,000 and a strong lawyer and a strong case, probably even an arthroscopic shoulder or knee can clear it. So it just depends, on what the limit is and what the injury is. But we always try to go for the maximum. But those were the recent ones, 2.2 on the lower back, 1.2 on the total hip replacement surgery. Although that total hip was not a new injury. It was already there before the fall. This was a fall case, a premises case. So he already had the need for a total hip replacement, just that he wasn't going to do it right away. He might have been doing it like in 10 years or whatever, but the doctor already said, look, you need it because you have this condition. But then the fall aggravated it and exacerbated it to the point where he needed it like right away. So we still got 1.2 on that, which was pretty good for an aggravation case. So that was a pretty good result, I thought, the 1.2. There was also a case that I did maybe now it's a year or two ago, where it was $1 million policy, a pedestrian knockdown, and there was a traumatic brain injury. And I tried to settle it for the $1 million. And at first they said no, and they were fighting, but then they tendered the $1 million for that. So if you have a traumatic brain injury, that's always a very, very serious injury. Okay, let's see. Here's a question. Marcus says, at-fault car ran the red light, causing 3 neck herniations and 2 back herniations, requiring steroids, injections, no surgery. Yeah, so I mean, if the at-fault car blew the red light, you would want to find out how much insurance they have, whether they have excess or umbrella, where it is, like what city. But yeah, herniations and with injections, that could be worth anywhere from, some people settle those for like lower amounts, like 20, 30,000. The most I think I've ever gotten just on injections was maybe 150 against a truck where it was a serious injury, but all he had was injections. So we ended up getting, I think, 150,000. So yeah, injections you could clear into the 6 figures, into the hundreds of thousands as well. Let me do this quick question. Here's a question from our channel. Hello, I'll try to make this short and to the point. Auto 18-wheeler accident. The defendant insurance company accepted 100% liability for the accident and already paid my property damage. They have given 3 lowball offers, and I've declined all of them. and filed a lawsuit. My question is how to file summary judgment on liability if there are no witnesses or physical evidence other than the damage to the car and the injuries. I had no pre-existing injuries and all the treatment is due to the accident. Who does the burden of proof fall on? Oh, yeah, so you could still file a summary judgment. You could just file it based on witnesses, like you're a witness, so you would sign a witness affidavit, photographs, the police report, and you would say it's a rear-end crash. And then the presumption is if you tender evidence that you're stopped and the other car rear-ends you, that's their fault, right? Presumptively by law, at least in New York, but in most states. And then I believe the burden then shifts to them and they have to come up with a non-negligent explanation. For example, if they sign an affidavit that, I was driving and the plaintiff, he slammed on his brakes for no reason, or he reversed into me. Okay, that would be a non-negligent explanation, right? That's why I hit him, because he started reversing into me all of a sudden, or he slammed on his brakes for no reason. But other than that, that's pretty rare. And even then, people try that. Usually the judges don't allow that either, because you can't be following too closely. You have to follow at a safe distance. So usually, you should be fine. You don't need like eyewitnesses or physical evidence. If you have photos of the cars, whatever you have, just submit everything you have. Affidavit is usually enough. The police report. They're usually not going to lie and say they're going to, say what happened. So you should be fine. You should get summary judgment on that. Okay, let me go back to this. And Marcus also says going to PTSD counseling as well. Oh yeah, if it's PTSD, that could be serious. Yeah, check out, I did some videos on PTSD a while ago. I'm going to try to do some more on that topic. But PTSD, there's some, people that say PTSD is worth as much as a TBI. So that could be worth much more if it's a real PTSD and you have treatment and you have the proof. That could be much more than just what you would get for just an epidural steroid injection. That could be much, much more. Okay. And then JC says, good evening, Mr. Frekhtman. In a mass tort, mass tragedy event, how is an aggregate settlement better than individual negotiation, if it is at all? Does that give you better bargaining power? Oh, you mean like settling for everybody? It just depends. I don't know. It depends on how it's done. Depends on which case. Sometimes they settle them all at once, some of the mass torts, and then each person still gets their individual amount based on how seriously they are hurt. So, but it's settled, for example, for like, I don't know, $3 billion or something, right? But each person still gets their share based on how seriously they are hurt, as opposed to each person just suing individually. I think they like the idea of a settlement because it gives them some kind of closure. If it's a big company like, Johnson & Johnson, whoever it is, one of those big pharmaceutical companies, they know, okay, we're going to set aside $3 billion or whatever it is. That's all our liability. It won't be more than that, as opposed to just, everyone suing and then you don't know what's going to happen. It doesn't have any kind of closure. But I would speak to your lawyer about that. It depends on which event, and I don't want to give you the wrong answer. It's a little bit too general of a question for me to answer. Just and Miss LPL says, hi Arkady, hi, how are you? Does a McDonald's have enough insurance to pay $30 million verdict? Owner owns 20 McDonald's. Well, you would have to, just find out in the discovery how much insurance they have. So it's possible. Usually McDonald's will have like at least $1 million. They might have excess and umbrella beyond that. I don't know if they're going to have like 30 million, but they should have something significant. And Marcus says, thanks a lot. Last question was in South Carolina. Will I get punitive damages for a car running a red light? Oh, no, you wouldn't get punitives for that. Punitives is like if you really are doing something malicious and terrible and evil, it has to be really, really bad. Just running a red light is not punitives. Punitives is like if you have a trucking company and, the only driver is like just drank a bottle of vodka and he's completely drunk, but the owner says, you know what, I don't care. We have to get that load over there. Go get in the truck and drive it anyway. And, and then, hey, wait a minute, it's really busy. It's rush hour. There are people. No, I don't care. Just drive 90 miles an hour with the open bottle of vodka or whatever. That would be maybe punitives. Punitives is really hard to get. It's not easy. But it has to be really evil, malicious, like wanton disregard. And basically you don't care. And that your conduct is going to injure people, but you do it anyway. So just running a red light is more like, that happens all the time. People just, whatever, they could be texting, they could be, just negligent in running a red light. So that wouldn't be punitives. Okay, and then H. Chambers says, hi, how is pain and suffering calculated? Love your videos. Yeah, so that's a good question, but it's not really, it's a big question, right? There's not really any formula. It's really just based on the way you present your case, right? So you have a trial. Obviously, you're going to call the injured party. They're going to talk about their pain and suffering. You can call witnesses like their friends, family. They can talk about how the person has changed, what they were like before. You can call doctors, and the doctors will talk about the injury, the diagnosis. You can do medical like MRIs, three-dimensional MRIs, whatever evidence you want to present. But ultimately, you can suggest a number in most jurisdictions. Some jurisdictions you can't, but in New York and most jurisdictions you can. And you can say this case is, for example, civil justice in this case is $1 million. Then it's up to the jury. They can agree with you and say, yeah, we're going to give you $1 million. They could say, you know what, that's low, and we think it's worth more and give you more, like $2 million. They could say, that's too much. You're a greedy lawyer. I don't think that it's worth $1 million. I think it's worth 300,000 or whatever, or maybe 10,000, right? They could be completely off. So it's really up to the jury, and you have to persuade the jury. And there's no real formula, because it just says in the pattern jury instructions, which are the instructions that the judge reads to the jury. And on the basis of those instructions, the jury then answers the verdict form. So the instructions just say like an amount that's fair and reasonable to compensate for the injuries, the disabilities, the pain, the conscious suffering, the conscious pain and suffering. It's just very general. So there's not really any scientific way that it gets calculated. So it's more like an art, not a science, I guess. It's more like an art. So if you can be very persuasive and say, look, this is the person lost, this was everything to them. This was their life and they lost it. What's that worth? That could be worth millions. And then the jury agrees with you, then they can allow for millions, And if they don't, if they think like they don't like your client, or they think the client's like a liar or maybe like a fraudster, then they can allow for a lot less. So it all depends. But that's like a big ticket question. And then John says, can child support be taken out of your settlement? Yeah, I believe child support can, because that's like a lien, and they're very strict with that. So yeah, child support, I believe they can take that out. They usually do. They usually send like a lien. So when we get the check, we put it in our trust account, account for the client. But then if we get one of those liens, we have to pay the child support, and then the rest goes to the client. And then Derek says, I'm back formally. Oh, awesome. Trying to help injured patients with you. Oh, great. That's awesome. Great to see you. Great to see you. And Ty says, what happened when the defendant admits liability? Okay, so if they admit liability and they sign a stipulation, that just means that they're not, contesting liability anymore. That means you win as to liability, the question of who was at fault. So you don't have to do a trial anymore as to that issue, as to liability, but you still have to do one as to damages, because they could admit liability. They could say, for example, we were talking about that case with the rear end, and somebody was saying, how do I get summary judgment? Well, if you file a motion and they could say, you know what, you don't even need to file a motion. We'll admit liability. We'll sign a stipulation. We rear-ended you. You were stopped. We are at fault, 100%. That doesn't mean that they have to also admit that they caused the injury. They could just admit that we hit you in the rear, but that rear end was just a little tap. It was a little fender bender. That didn't cause your injury. Your injury was from living your life. You had that before, right? And they could fight you on damages. And you say, I have like this and this, and I have surgeries. And they say, okay, great, you have surgeries. Not from this little fender bender. And they could fight you on damages. So but liability is one piece of the puzzle. So I guess admitting it is good in some ways, although some lawyers actually don't like it, because sometimes, if they admit liability, now you lose that. If it's like a real bad conduct, like if they were driving really fast, there was a school zone and it was a company car and they rear-ended you, and now they'd say, we admit liability, but you're going to get liability anyway. And now, the jurors are just common everyday people that are being pulled away from their everyday life and being put into this new world, like a courthouse, right? And they're being shown these presentations, and they have to be judges and decide the facts in this trial, jurors in this trial. So for them, I mean, a lot of people, when they see bad conduct, they want to punish the bad conduct. But if they don't hear about the bad conduct because it's just been admitted, and you say, okay, it's just been stipulated, it's just been admitted, it's already been decided that the defendants are at fault, and now the only issue is your injury, and they're contesting that, it might be weaker. So in some cases, it might be good to keep the injury in there if it's like really bad conduct by the defendant. So some lawyers do it that way as well. Okay. And Chris Colt says, thanks for all your info and help. Oh, thank you so much. Thank you. Thank you for watching. I really appreciate it. Yeah. And Derek says, I'll be able to do the podcast in the middle of August. Just won my workers' comp case, and I'm going to have a good place to record from. Oh, awesome. Congratulations. That's right. I remember we talked before. That's right. That you had the workers' comp. So you won the case. That's awesome. It's great to hear. And he says, you have inspired me to start creating content to help workers' comp claimants. I'm going to start next month. I'll let you know the channel name soon as well. Yeah, absolutely. Let me know. I'd be happy to do that. We could do a podcast. We could talk about your experience, and I could give you my input, and you could talk about workers' comp. Yeah, that would be great. That would be great. And we put a few videos also on the channel where sometimes people call me for consults, and I'll say, well, do you mind if I record this and maybe even publish it? And some people say, yeah, sure, no problem. And I think I put one or two of those on there. So let me know if you guys are interested in that. And if anybody wants to do that, I would be willing to do that as well. I could call you, do a free consultation. We would like record it, I guess, just audio, unless you wanted it to be like on this video, we could do that as well, but just audio. And then I would have my video or my editor, remove like your name or anything confidential, and then just the facts of the case, like what happened, how the crash happened, or how the fall happened, the injuries, just the general stuff would be played. We've been doing a few of those videos as well. I think those are interesting. Okay. And JC says, is there proof of gross negligence? Oh, if there is proof of gross negligence, how does the punitive damages play a factor in any potential settlement? What if there is state caps on exemplary damages? Well, yeah, if you have caps, then you can't get them because that just means that they don't exist, right? Caps just means they put a ceiling on it. So that just means in your state they don't exist. But if there's no caps, yeah, you could say that I want to get a bigger settlement because of the possibility of punitive damages. Usually, I haven't seen too many settlements. Usually, punitive damages are verdicts. Like, you have to go and take a verdict, and then the jury has to decide how much money will I allow for to punish them because of this terrible conduct. So usually that's a jury question. Okay, and then Playboy says, one summary judgment, but the judge vacated the note of issue. This system is confusing. Oh, okay. Well, that's good that you won summary judgment. That means that you've won on liability, like we just talked about. But if you vacated the note of issue, that means it's not on the trial calendar anymore. So probably there's some sort of discovery that you have to do. And once you finish that discovery, then you can put it back on the trial calendar. Yeah, unfortunately, they do that. I don't know why. Sometimes it'd be good if they just left it on the calendar, let you do the one deposition, whatever you have to do, because it's not like the case is coming up for trial tomorrow anyway. You get that done, it's still on the calendar, and then they give you a trial date. But sometimes they are very strict about that, and they just want to take you off the calendar. But that means you're not in line for the trial anymore, and you have to get back in line, and basically just means you're going to have to wait longer. So it's a little bit unfair. And he also says defendant admitted liability in the deposition, so we won summary judgment. Oh yeah, discovery was not complete. Yeah, I guess there's some kind of discovery you have to finish. And then Wayne says, Arkady, a little more discussion on holding LLC responsible for the owner, CEO, negligence for rear-ending a van in a restaurant. Yeah, okay, I'll look into that. I mean, usually I think that's going to be a state-specific rule, so you might have to ask your lawyer to do some research in your state. But usually if it's a LLC and the LLC owns the car, you could sue them if he was like in the course and scope of the employment, or if he was working for the LLC, right? Then you could sue the LLC. Usually, I think that's the rule. If he just happens to have an LLC, but he was driving his own car, personal, and the LLC had nothing to do with it, then it would be harder. So, but if it's in the course and scope of the employment, then definitely they're liable. Let's see, what question are we up to? I just want to go back, make sure I didn't miss anyone. Okay, and H. Chambers says, what do some PI cases need to tap into the excess umbrella insurance policies? How serious do your injuries need to be? Yeah, so I mean, basically, I gave some examples. Like, for example, it just depends on what the primary policy is and what the excess is. Like that case where we got 1.2, that was in the excess because that was a case where, it came from a prior lawyer. The prior lawyer was trying to settle it for a few $100,000. All he knew was that there was $1 million policy. They didn't even want it. We said, well, did you find out if there's excess or umbrella beyond the million? And they said, well, not only did we not find out, what difference does it make? The case isn't worth more than $1 million. So we didn't even ask. So we were just going to settle it for a few $100,000. But we took a different position. We found out that there was, and there was actually a lot. There was like 25 million excess. So then we pushed on them. But because it was just an aggravation of an injury that already existed before this incident, we couldn't really go, wouldn't be credible to go and ask for like 20 million. It just wasn't that kind of case. And it was a surgery. And we thought that at one point I was even trying to get more. I was trying to get like, 2 million or 3 million because I was thinking that the doctor was going to give me a lot of future medical expenses that I could then use that to get more money. But the doctor unfortunately said, look, I did a great job. I did the surgery on the hip and everything's great. He doesn't really have any medical expenses. Maybe if in like 20 years he needs another hip replacement, that could be $70K. That's it. No other expenses. Meanwhile, my other trial, the one where we got 2.2 million, the doctor said there's like over 2 million just in medical expenses because there's going to be a revision, there could be another fusion, this, that, adjacent segment disease. So, you never know. It just depends on what the doctor gives you in that particular case and in that particular injury. So you have to just kind of get into the weeds and look at the nitty-gritty of your case. But yeah, usually that's what you need to get into excess or umbrella is just a serious life-changing injury. And usually umbrella will be, although, I don't want to say usually $1 million. $1 million, in this case, it was $1 million. And then after the $1 million was the umbrella. But sometimes what you could also have is a 250 policy, meaning 250,000, but then there's $1 million excess. So that's a little easier, right? Because if you have, let's say, a fusion, you easily clear the 250 and now you're into the $1 million umbrella. So usually like a serious injury, like a fusion, traumatic brain injury, it could be a lot of different things, but okay. Let's see what other questions we have. Derek says, usually around the trial date, the insurance company is a lot more willing to talk about settlement and mediation. Yeah, definitely. They're a lot more willing around the trial date. I agree, because that's when you have their feet to the fire, kind of like they have to settle. And if they're not going to settle, well, then you're going to go to trial and you're going to get a bigger number. So it's either pay this or pay more, right? As long as the case is prepped, the case doesn't have any major problems, you could use that as a bargaining chip. I love to do that. And Payne says, what happens when you file a motion to compel in New York? Defense attorneys have not submitted any discovery for 1 year, ignored multiple court orders, ignored good faith letters from the plaintiff's attorney. Yes, you just file a motion to compel, and then the judge will just say that they have to give it to you. But that's what I was talking about that earlier. I don't know if you were watching, like earlier in this video, in the beginning, somebody asked that. The only problem is that, it could take time. Like I did that in Queens on a case. They were supposed to produce a corporate representative who was supposed to be like the voice of the company. And they produced somebody who didn't know anything. So I made a motion. I had all this case law. I said, look, and then the judge just kind of took, I don't know, even, what was it, like 9 months or something to decide it. And then even in the decision, the judge was just like, we had a conference like on Zoom, like one of these, but it was live. And the judge was just like, oh, this is a discovery issue. What do you want me? What do you want me to do? I don't want to deal with discovery. It was like beneath him. And he didn't do anything. So I waited 9 months and then he didn't do anything anyway. So it's very frustrating sometimes with these like state courts in New York. Unfortunately, I hear in other states it's a little bit better, like in, I don't know, California or whatever other states, Florida. You file a motion, you get an order. They actually follow some kind of rules. In New York, we didn't have this. It's called 30B6, or we call it, I think, 20220D or something. This corporate representative idea that you can designate. You could say, give me a corporate rep, and then give you somebody, and then that person speaks for the company, and whatever they say binds the company, which is very powerful, because then if the person says, for example, I don't know, and that's not just them saying I don't know as an individual, but it's the entire company. Like imagine you're suing FedEx or McDonald's or whoever, the whole company is saying we don't know, and then you could use that at trial. So you could still do that in New York, but they came out with the rule in like 2021, and it seems like whenever you try to do that, there's not much case law on it, because it just came out fairly recently. So it's hard to get enforcement. It's hard to, and I'm sure with you, in your case too, you're trying to get, I don't know, whether it's document discovery, whether it's depositions of parties with knowledge. You just have to keep fighting. Yeah, that case I ended up actually settling for a pretty good amount. I think it was on the trial calendar. I ended up settling for like, I think, was it 575 or close to 600,000. But but you just have to keep fighting. I mean, I would file a motion. I wouldn't wait a year. They only have 30 days to respond if it's document discovery. So if you file the motion, I mean, if they didn't give you, if 30 days passed, just file the motion. And then, some places like in Brooklyn, they've been pretty quick. They sometimes decide those in like 2 weeks. And then you get a decision that they have to give it to you. Then you send them the order. If they still don't give it to you, file another motion. Now ask for like sanctions. You just have to be tough and keep fighting it. You can't if you have to keep very, very, keep kind of like your foot on the gas, keep fighting it. Because if you let up, then they're going to be like, okay, and they're not going to do anything, because all they want to do is delay. So you have to be very careful with that. Okay, and then Katie says, do school buses normally carry high insurance? Yeah, private school buses usually do. Absolutely, usually at least $1 million. And Taj says, hey, Arkady, my attorneys tried to settle my slip and fall case via insurance claim, but my statute of limitations were drawing near, and we filed a lawsuit against Philadelphia Insurance. What can I expect moving forward? So, yeah, it just depends on how close they were in the settlement. So if they were trying to settle and it was close, and now you have a lawsuit, that's a good sign. It means you didn't, obviously you have to file a lawsuit. You don't want to blow the statutes, and the case is dismissed. You can't do anything. So now the case is in court. So I would just, as long as the lawyers are trial lawyers, they're moving the case along, they're pushing it, they're going to get you the maximum, you feel confident in them, let them work it up through the lawsuit. Let them do discovery, depositions. If you're close, if you're looking for, I don't know, for example, if you're looking for 200,000 and they're at 150, maybe you could bridge the gap and settle it for 180 or whatever, But I don't know how the settlement is going. But if they're asking for $1 million and the other guys are at Philadelphia is at 10,000, well, then you're going to have to keep litigating and probably get it closer to when you pick a jury, or maybe have to go all the way to trial. So, but it just basically means the lawsuit was started, just like any case. So it's just started, which is good. Okay. And Derek says, I think a good thing to talk about is how you answer in court, to just answer the question with 1 or 2 sentences. With most of the answers I choose to use are yes, no, I don't know, I don't remember. Just answer simply. Yeah. Usually I think that's true. Just simple answers are good. Unless it's something like your injury, then maybe you can go into how the injury is impacting you, or have other people talk about that, like your friends, your community witnesses, things like that. And then Derek also says, can you explain some of the issues you have seen from clients having to have a spinal fusion and the future procedures that they had to undergo after the fusion? Yeah, spinal fusion is really serious. So yeah, the issues are, you have the hardware in your spine, then you might have adjacent segment disease, then you might need for example, if you have a fusion at C4, C5, anterior cervical discectomy and fusion at that level, now you might need one at C5, C6, which is the adjacent level. So that happens very often. And then you need 2 surgeries instead of just 1. So, it's very serious. Also, there's something known as non-union. So if you get a non-union, then you need another surgery to fix that. It just means that because they're hoping that everything's going to bridge together. You lose mobility at that one level because they're removing the disc and they're putting in allograft and they're fusing it with like a kind of like a cage, right? That box with screws and titanium. But what if it doesn't fuse? That's non-union. Then you need to do another surgery. So yeah, it gets pretty complicated. There could be a lot of complications. Yeah, he's saying like adjacent disc disease revision. Yeah, those are serious. I could do a video about that. I could do a little research about that. I had a fusion trial last August. That's the one where we got 3.5 million. So I did a lot of research. I watched some YouTube videos, but they were by doctors who do a lot of fusions, and they were videos meant for other doctors. They were like teaching, but I wanted to like really learn about it. So I watched some of that. So I remember I learned a lot about that. I have my notes somewhere for that. I could review those notes and talk about that a bit. Maybe do another video about that. It's not too boring. People are interested in that. It's a little, very specific, very like medical. But I guess if people are interested, I could do a video about that. And Taj says we filed in June. Okay, yeah. So if you filed in June, yeah, Philadelphia was probably served by now. Yeah. I think so. I mean, yeah, if you filed in June, yeah, probably right about now, about 30 days is when you serve it. So they should be getting ready to answer pretty soon. And then Crystal says, hello, Mr. Arkady. My injury is with Target, premises liability. Have you ever filed a lawsuit against Target? Yeah, I think we have. In New York. We've had a few cases against Target. Yeah, I think I can't really remember anything specific about them. I don't think any of the cases really went very long. Maybe they settled or they were kind of more on the smaller injury side, but Target should have, sufficient insurance and everything. So it should be a good case. And Derek says, can you go over that fusion case, how you got it up to 3.5 million, how you worked up the numbers to get that number? Yeah, sure. Absolutely. I'm happy to do that. Yeah. I think I did a few videos about that case. You could take a look, but I could maybe do another one. I mean, that case, we had a bunch of numbers. Like we had future medical expenses. We had, I don't think we had lost wages, but we had future medical expenses, and they were pretty high. And we had pain and suffering because he had multiple surgeries. But what happened was that we just negotiated it because when you added up everything we had, it was really high. It was like 20 million. So I think they got scared. They like, oh my God, 20 million. So they were like, we have to start paying. So they were like $1 million. And the judge was actually yelling at us, you got to take $1 million. And, we said, no, we can't take $1 million. But then finally they went up to 3.5. And at that point, the client wanted to take it. So yeah, I could do a video about that, another video. And Kalis says, hi, how are you? Great to see you. He says, hi, Arkady. It's a truck rear-ended case, defendant accepted liability, percutaneous lumbar discectomy, shoulder surgery, shoulder arthroscopy, aggravated neck herniation with 3 epidural injections, recommended, and $1 million policy still on the treatment. What can be a typical settlement? Well, if it's here in New York, if it's a truck accident, I mean, I don't know if is it in New York or somewhere else. If it's in the New York City area, I would say truck rear-ended case and with liability, percutaneous lumbar discectomy. I would say, I've settled percutaneous cases for like $550, $600, but if you also have a scope arthroscopic on top of that, it could be more. It could be $700, $800. It's hard for me to say exactly, but definitely it could be something like that. Percutaneous plus you say that there's excess, so you'd want to find out how much excess there is. That's important, because you don't want to be trying to settle a case without knowing how much they have, right? So first find out how much excess there is, how much umbrella excess there is. For example, if there's 1 million with 5 million excess, and then you have to make sure that you're done with all your treatment. Like if you're going to think about doing maybe like a fusion, then, I wouldn't settle it, get all your treatment done, because that'll make it worth more, like 2 or 3 million, right? If you're definitely not going to do the fusion or anything else, and you're all done with all your treatment, then you can try to settle it. Like you have the discectomy, you have the arthroscopic shoulder surgery. I think those two things together could be, anywhere from like 500 to like maybe 800 or something like that. If it's in New York City area, if it's somewhere else, I wouldn't really know. I could do a little bit of a research for you, maybe a verdict search, but it's hard for me to say because, different venues have different value ranges usually. And then MVP says, if you're a passenger in a car accident, does that automatically qualify for summary judgment? Yeah, usually. I mean, yeah, of course, because you're a passenger, you didn't do anything wrong. So it's just a question of, who among the two cars that crashed was at fault. But you wouldn't get a percentage unless like you grab the wheel or something, which is pretty rare. So yeah, you wouldn't be at fault. And Derek says, I'm having a settlement battle right now with a similar issue. And Kelvin says, hit the like button. Yeah, that sounds good. Thank you. And Derek says, I got 280K to 600K number, but I couldn't get them to settle. They tried to leave out the medications and future care I would have needed, offered a 75% disability. Yeah, that's the workers' comp case, right? And then H. Chambers says, I've had 3 surgeries, 2 left shoulder, 1 revision from a labrum surgery, lower back, herniated disc surgery. Is that enough to tap into excess umbrella? Yeah, depending on how much umbrella they have, you have to look at what the policy is. Like, for example, if it's $1 million policy and then they have 5 million excess. Well, if you had 3 surgeries, 2 left shoulder torn labrum surgeries, and a lower back herniation, but is that a fusion, the lower back surgery, or just a percutaneous discectomy? Because usually, like if you have 2 labrum surgeries for like arthroscopic and 1 perc disc, it might not be enough, right? Because like the person who just asked that same question, I said a Kalis, right? He just asked that, or she just asked that same question. We were talking about maybe it's worth like 850, right? So it could be only worth 850. But if it's a full-blown fusion and 2 labrum surgeries, then it could be worth, like 2 million. So if it's a 1 million excess, then you get the 1 million plus you can be into like the 2 or 3 million range. So it just depends on how much. Now, if it's a 250, this is the primary, and then they have 1 million excess, then it's easier. It just depends on what the primary is, because they're always different. Sometimes it's 250, sometimes it's 1 million, and then what the excess is. But you always try to go for excess if you can. And then Hacks says, I know you get this question 1 million times. I have 2 herniated discs in my neck, getting an injection soon. The other driver was 100% at fault. Estimated value. Yeah, the herniated discs, if it's just a herniated disc with an injection, I think I answered it earlier in this video. I said, like, usually people settle injection cases like epidural steroid injections anywhere from like 20,000 to like the most I've seen is like 100. Most I've gotten is 140, 150. But usually if it's just like a soft tissue herniation, it's going to be worth less. A lot of people settle those only for like 5 or 10 or 15. It just depends on where it is and how, So basically, it's just it just depends on where you are and all the facts and circumstances. So it's too hard to say like, it's a car crash, I have a herniation, what's it worth? Because every case is going to be a little bit different, like the property damage, the venue, how you come across, how are the depositions, what's the liability, all these things. I think I did some videos where I talked about all the factors. But yeah, it could definitely be worth some serious money. Sometimes people even get, like I even did a few videos where people have gotten like 2 or 3 million on a soft tissue. Like I think there was one case where somebody won 3 million on a soft tissue. So it's possible. It's not like the norm. I don't want you to think that's it happens every time, but it's possible. Okay. And H. Chambers says, no fusion, just a herniation, and had a microdiscectomy and laminectomy. Okay, but if it was a laminectomy, that's a pretty serious surgery. That could get into over 1 million easily, depending on the venue and everything. Yeah, for sure. And Brooklyn says, they found out that I have a pinched nerve through an EMG. I want to close my case. Should I? I've done everything else. It's just dragging out without any surgery. Just test after test. Well, the fact that they found that you have like a herniated disc or some kind of injury, bulging disc through the EMG is good if the lawyer knows how to use EMGs, because EMGs are objective evidence. Because one of the defenses is that, hey, this is subjective, meaning you're saying that you're hurt and we have to believe you. But an EMG is where they hook up those, stickers and basically how it conducts electricity. And I think they even listen to the sounds and they watch the fibrillation potentials, like those waves. And then the doctor will say, okay, hey, there is radiculopathy, meaning there's radiating pain, like in your neck, traveling to your arms, or in your lower back, traveling to your legs. And they confirm radiculopathy. And usually it's a neurologist with the EMG testing. So that's objective evidence. So that's very powerful. I use that. In fact, in the case where I had the 3.5 million, we had an EMG, and I actually had that as part of my timeline. I had a whole EMG. I had the fibrillation potential. I went into that because I think that's very powerful, because if you have objective evidence, these are like electrical impulses. You can't fake that. You're hooking up electrodes, and like that's what it shows. It shows what it shows. You can't fake that. So that's strong evidence. I would use that as long as the lawyer knows how to use that properly and how to present that evidence. That can be a big case. And Jay Frag says, we have spoken in passing about my elevator accident. It resulted in multiple herniations and bulging discs so far. I've had a 2-level spinal fusion, lumbar microdiscectomy. Will be having more surgeries. I've had complications such as I can no longer feel much of my right foot and have dysphagia now and vocal cord paralysis. Any idea on valuation? Yeah, I mean, that's really serious. It's better to text me. Just text me. It's 347-566-9595. Here, I'll drop it in the chat. I'm happy to speak with you again. I could look up the case in the court's computer. The public, if it's in New York, I could look it up in the court's computer and I could tell you like what's happening. I've done that. I did that for somebody today, actually. I looked up a case for somebody. It was like a trip and fall case. And I looked at, there wasn't much. It was just like a lawsuit and it was just starting, but the guy was really thankful. He was like, oh, this is so great. You're speaking to me. So I'm happy to do that, and then I could tell you more about what it's worth. But I mean, look, if you've had all those injuries, that could be a huge case. As long as there's enough insurance, that could be a huge case. That could be worth many millions if you have right foot and paralysis. I mean, paralysis, the vocal cord, and all these injuries, and the surgeries are worth a lot too. Like 2-level spinal fusion, that by itself could be a big case. So as long as the liability is strong, then I think it's good. As long as you have a good trial lawyer. That's the other thing I could do, is if sometimes people will ask me about their attorney, and I could do some research and then tell you, hey, here are the verdicts for this attorney. These are the past settlements verdicts. And, you could look for yourself and see, hey, is this something that, I'm happy with? Like some lawyers, their verdicts are good. They have 2 million, 10 million, whatever. And some people say, oh, I got millions, but then you look at their verdicts and they got $4,000 or something, or 0, 0, 0. That's not so good. So, I could do that for you as well. Okay. Aylin Cat says, I've developed bone spurs on my spine after getting whiplash from being rear-ended by a teen on her phone. My doctor says this is a permanent condition. Oh, I'm sorry to hear that. Yeah, I mean, bone spurs are pretty serious. And rear-ended. Yeah, rear-ended. And I'm only 24 and can no longer lift my own children, but my attorney consult felt really off. Yeah, feel free to text me. I mean, if I know an attorney in your city, maybe I could recommend somebody. I usually do know attorneys in most major cities because I've done a little bit of research, like through the same databases, to see like which attorney is going to trial, which attorney is getting multi-million-dollar verdicts, and then I'll add them to like a list so I could then maybe recommend someone for you. Yeah. Oh, in Kansas. Okay. Near Kansas City and Topeka. Yeah, I think I know some lawyers in near Kansas City or near Kansas. Yeah, I should be able to help. Okay. All right, we're almost at the 50-minute mark, so we've been doing it for a while. Let me know if you have any other questions. If not, I guess we could wrap it up, but we'll try to do another one next week. And also let me know like what topics you'd want to see for the regular channel for the video. I'm still doing a few of the last week tonight where I go through the comments and I answer some of the comments. And I'm doing a few, just a few different videos on different topics. I'll probably do a few more verdicts, stories, some interesting cases. So, you know, whatever people want to see, I want to make sure that the content is what you guys want to see. So if you want to see something, just let me know and I'll do it for you. So please like and subscribe to our channel. Let us know what questions you have. We are here for you, and all the best. Okay. Have a great day and bye-bye.